Today, we're going to look at the second part of interlocutory applications. And so we'll be talking about injunctions. Now, an injunction is an order of the court which is used to compel a respondent to do an act or to cease from doing an act. All right. So when interlocutory applications are made to the court, the relief that the applicant would typically be seeking would be for the courts to make an order granting them something. And the orders that the courts make are referred to as injunctions. Now, injunctions are reliefs that the court grants at its discretion, all right? And that's why we say that they are equitable remedies. And because from one case to another, from one application to another, the court has discretion to determine if it would be just to grant an injunction or not. And of course, in an exercising this power, the court would always do it in a judicial and in a judicious manner, which means the court would do it to reflect the best interest of justice in that suit. So the first injunction we're going to talk about is an interim injunction. An interim injunction. Now you see that an interim injunction is that order that is made by the court to grant relief to an applicant pending when a motion or notice on the subject matter will be heard. All right. So as the name implies, it's interim, it's temporal, it's not permanent. All right. It is used in cases of urgency where you are trying to preserve the status quo, the subject matter. Right? Status quo refers to the subject matter of the suit. Let me give you an example. If we have a land dispute, for instance, let's imagine that I have a land dispute against you, and while the dispute is in court, you get a report that I want to start constructing on the land while the dispute is ongoing. And that land in question is land that you want to use for agricultural purposes, for instance. And if I begin any kind of construction work, it would permanently render that land as unsuitable for the purposes for which you want to use it. Now, you see that if you don't act very swiftly in that circumstance, right? Maybe you just heard that in 2 days I'm going to start the construction. If you're not able to get some quick relief, then permanently the land will be damaged, and the suit really would be pointless, because even the court would rule at the end that you are the owner of the land would not be suitable again for the purpose for which you want to use it. And so because you're seeking a quick relief, you make an application to the court for an interim injunction to be granted to you, pending when the court could hear from two of us regarding that same thing you're applying for. All right, so interim injunctions are applied for when there's urgency, when there's an emergency, when the status quo is at stake and you're looking to preserve it. Now, how is the application made? It's made by motion ex parte, of course, supported by an affidavit and a written address. Okay, so when the court grants this order, if you listen to the last video on interlocutory applications, you'll see that the order is an ex parte order, and so it's not permanent. All right, it's a temporal order. It would last for only 7 days, but then you could reapply to have it renewed for another 7 days. All right, an order that's made ex parte, as you can see on the screen, it abates after 7 days, but could be extended for another 7 days, and that's why I said it's a temporal relief. So within those 7 days, you see that you would have the opportunity to get relief to preserve the status quo, and within that time, you would also have made an application on notice, and the court would now hear from you and the other party, and then be able to make an interlocutory order, which would now last until the end of the suit. Okay, so an interim injunction again is used where there's urgency, where you're trying to preserve the status quo. All right, so the key words in terms of answering questions, the key words you're looking out for in a scenario or a question that would enable you know that you are supposed to use an interim injunction is when you're told that there is some urgency. All right. Once you're told there's urgency, you know it's an interim injunction. Or when you're told that you're to make an application pending when the court hears from both sides, then you know it's an interim injunction. So that's it for interim injunctions. I hope you've learned a bit about something new today, and I'll see you another time. Bye for now.